Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Merchant Shipping Amendment Bill 2015. To discuss the issue, I have with me Captain Sanjeev Verma, Master Mariner and former Vice Principal of FOSMA Maritime Institute, and Rahul Dhawan, Managing Partner, Lex Chambers and an expert in maritime laws. But first, the headlines. The Merchant Shipping Amendment Bill 2015 mandates all registered owners of any cargo vessel to have compulsory insurance cover. All the vessels will now have to carry mandatory certificate on board. And the government can now appoint wreck receiver through a notification. The Merchant Shipping Amendment Bill 2015 mandates that the registered owners of any seafaring cargo vessel have compulsory insurance cover. By doing this, the insurer can be called in to salvage the environmental damage caused by the insured polluting vessel through compensation.
India is a member of International Maritime Organization, and as and when Government of India approves to be a party to an international convention, the convention is given effect by suitably incorporating its provision in our domestic legislation. The accession to Bunker Convention 2001 is now approved, and for implementing the convention, the Merchant Shipping Act 1958 requires further amendments. After the bill is passed, Indian waters will also be protected from wreck hazards.
This bill has been adopted from an international convention. Now, the law of seas is such that it actually follows a public international law pattern. The public international law pattern itself is founded on these conventions. Conventions of the United Nations or conventions of the other countries and all, where everybody will be a signatory. Now, as a public international law principle, if a country is adopting a particular part of an international convention and bringing into its own act, its own law, then I see it as a complete pattern of following the international laws as far as the law of sea is concerned.
The Merchant Shipping Amendment Bill 2015 includes ships of 1,000 gross tonnage and above should carry insurance certificate on board in order to establish that it maintains insurance or other financial security. The certificate will enable the vessels to enter or leave ports. The liability cover for bunker pollution damage and the limits of liability shall be equal under the national or international limitation regime. The liability cover shall not exceed an amount calculated in agreement with Convention on Limitation of Liability for Maritime Claims 1976. This convention limits the compensation to 5 million monetary units for up to 500 gross ton ships where the country is not a member of International Monetary Fund.
From the environmental perspective, the compensation can be claimed for cleanup purposes, for the artisanal fishermen, the coastal tourism operators who suffer a damage as a result of an oil pollution. And now this actually, as it is said in the International Maritime Fraternity, the Bunker Convention completes the loop of compensation damage now that the Bunker Convention has come. That's one. With regard, because as per that convention, whether it was a civil liability convention or the Bunker Convention, the ship owner is required to maintain a compulsory insurance cover to pay his part of it in case of a claim.
The amendments incorporate the convention provisions. India is already a part to the Nairobi Convention and Salvage Convention. But in view of experience, it is necessary to make them progressive and in tune with Nairobi Convention and Salvage Convention. The bill was introduced by the Minister of State for Shipping P. Radhakrishnan in the Lok Sabha. The bill is likely to protect and manage sea environment by following the international standards.
The amendments in the Merchant Shipping Amendment Bill 2015 are being looked at as a positive step. Experts believe this would help India reach international standards when it comes to protecting the environment. With cameraman Ashwini Kumar, Dipali Pandit for Rajya Sabha Television.
On the point of wreck removal, how do you see the proposed amendments addressing the issue of wreck removal?
How the amendment is going to help is they are recognizing the fact that wreck removal is a thankless job. What typically happens is when there is, let's take the example of the River Princess at the Candleum Beach in Goa. Now, the state machinery was negligent, should I say, in acting at the outset. If they had acted, let's say, around 2001, they could have easily salvaged the vessel. So, which would have made issues simpler. There would not have been such heavy costs and so on and so forth. However, since they allowed the vessel to stay on shore for almost good 10 years, the wreck had to be removed. So the government of Goa called upon certain experts, and we happened to advise one of the partners in the JV to remove the wreck. The difficulty in wreck removal is that there is a portion of the vessel which is above the sea, and there is a portion beneath the sea. So above you can easily, so you have to cut it out. So unlike why you have to remove a wreck is that because it's there in the seabed. You have to cut out each portion of the vessel very carefully so as to avoid soil erosion, so as to avoid any kind of any kind of damage to the ecological system. As you keep going down, the process becomes difficult, and what happens is typically because of the non-understanding of the whole mechanism of wreck removal. Even if experts have removed, let's say 90%, 95% of the wreck, and there is only 5%, it will not, typically if you look at the IMO conventions and the other conventions which have been followed, it will not typically harm neither your tourism, neither any kind of, any kind of exercise which has been taken around that area, so that small portion, that balance 10%, should not be a problem. Unfortunately, our state machinery does not understand the fact that it means that you have to remove the 100%. It's not a car. It's a huge wreck.
I get it. So the point you're saying is that it's a finer understanding of the practice of wreck removal which needs to be acknowledged and represented in the legislation.
Very right, very
Correct?
right. And in fact, the most important, as I say, it's a thankless job. It's very difficult for
when you
any
say
private
thankless,
sector.
which means essentially the compensations are not sufficient. Is that what you
So
say?
they follow a principle of no cure, no pay.
Okay.
Now, difficulty is who understands this fact of no cure, or what is no cure?
But they have addressed it. No cure, no
Yes.
pay.
Now what they are trying to do is they're trying to
So
make
that's
it
a
little
positive
easier.
development.
Absolutely, absolutely. And I hope that more private players are looking at it, because if you see, there is a trend of people moving out from this business, or people not wanting to look at this as a piece of business. To my mind, it's very important, and more from an ecological point of system, because as you see, it is the owner who is responsible. But the minute the owner runs out, because there is a P&I club with an owner, the minute the owner runs out, it is the state, it becomes the state's responsibility.
Responsibility too.
So that is where it is very important for the state to understand that if you are inviting a private player to remove the wreck, it's an important and a technical procedure. You got to appreciate the experts. You got to sort of move in that cohesive manner of working, and cannot be, there cannot be a friction. Cannot politicize the issue of saying one party gave a tender to a particular player.
Got it. I'll get in, Captain. Captain, from the seafarer's point of view, as you were mentioning, and there is the owners of these ships need not always necessarily be from this country, can be from anywhere in the globe. In that situation, in case a wreck happens and a removal is required, what is the role of the captain of the ship, and does he continue to be nagged by the
That's
state?
where that's my apprehension with this amendment, that the owner is not easily traceable. We take the case of motor tanker Pavit. She drifted off from the Oman coast and was suddenly found on the Juhu beach one fine day. And how do you trace the owner? The ship is not registered in India. It could be a single ship, single company affair. Similarly, the Black Rose, she broke off with the cargo of iron fines of Paradip port, and that ship is still lying there, and so has the rack carrier with the coal, 60,000 tons of coal, of 20 nautical miles of Prongs Reef Lighthouse is still lying there.
Oh,
So how do you trace and who is to blame? The owner might say that the wreck happened not because of the fault of my ship. There was an uncharted shoal, or there was an act of God. You know, you're anchored off a port and a cyclone comes through and takes the ship onto the shore, and the ship breaks up. So is that the fault of the owner? He will not take the responsibility for getting. His insurance company will say it's act of God in this particular case of cyclone. Or there is the master of the vessel has taken a decision to alter course to avoid a collision, say with the fishing vessel or another vessel, and he runs aground because of a shallow patch. There's so many ifs and buts. There's so many ifs and buts.
So the point is
the
that
implementation is not easy.
so if the state has to move in and eventually it's the responsibility of the state, do you see the state empowering itself through this amendment
No, I don't see
to
that.
take care of such issues?
I don't see that.
You don't see it. Do you see that?
While I beg to differ from my learned friend, because I think the fact that to have an insurance cover must on the vessel today,
Okay.
I think is of utmost importance. So, what is an insurance cover? There is a PNI club behind.
But how do you
all
address the
owners.
drifting of...
So I'll explain you how this happens. Is typically now, I mean, we have to give some credit to the state instrumentalities where they've done some good job. Is that they are now accepting only vessels which come in with proper PNI club covers. Which means that any vessel which is coming in which does not has an appropriate PNI covers, and I must add here to say that there are about 13 PNI covers which are recognized. So let's say, for example, a owner runs out, as sir pointed out, that the owner runs out and we are not able to sort of trace the position of the owner. And let's say the PNI club raises his hand and says, sorry boss, I cannot help you for whatever reasons, whether act of God or otherwise. The PNI club is there blacklisted by the state instrumentality, and therefore it loses a lot of business. So therefore, what will happen in future if there is the same PNI club is also covering another vessel for a different owner?
That
our
gets
state
affected.
instrumentality will not accept that vessel to enter.
Great.
So that, to my point, is something which we must credit the state instrumentalities to have recognized that
And inserted.
have asserted.
Codified,
be
yes.
inserted.
Time for a short break. Coming up, the amendment empowers the central government to appoint any person as receiver of wreck through a notification. The amendment in the Merchant Shipping Amendment Bill 2015 empowers the central government to appoint any person as receiver of wreck through a notification. The bill also provides for duties of the salvor, owner and master of a vessel.
Once the bill is approved by the Parliament, the ship owner will be empowered to remove wreck from any area across the world where the wreck is present. The existing provisions does not have this clause, resulting in the shipwrecks to be left in the water causing pollution.
A ship used to get wrecked in a country's territory, and the ship owner would claim money from the insurance and leave the wreck as it is. It used to be a danger to the navigation, and if it was carrying any dangerous cargo, that eventually, if part of the ship that sinks, over the years the tanks holding that cargo, they rust and they become weak, and the dangerous cargo starts seeping into the marine environment, affecting the marine environment. And the country's government where the wreck happened, they used to go to the flag state of the country where the ship was registered, or to the ship owner. They would lift up their hand, well, we are not going to look into it. Now with this wreck removal convention, the similar approach, the ship owner has to maintain a compulsory insurance cover, and it is his responsibility to have the wreck removed wherever in the world it happens.
According to the proposed amendments, a wreck will be considered hazardous on the basis of the type, size and construction of the wreck, the depth of the wreck in the area where there is wreck. Range of tide and currents in the area would be another factor to determine the hazardness. Nature and quantity of the wreck's cargo, height of the wreck above and below the surface of water at lowest astronomical tide and vulnerability of the port facilities, proximity of tourist spots and heritage locations, Submarine topography are also some of the factors that will determine the intensity of the wreck hazardous.
And if I talk about the wreck and salvage part, there were a lot of ambiguities so far, especially in the part of the salver, whether he gets his reward in right time. So far, we were only talking about no cure and no pay. But today, after these rules come in force, at least they will be aware that even if they prevent the pollution on the territorial seas of coast of India, they will still be rewarded. So there will be a proactive decision taken by people, and things will be definitely improving.
Public and private entities will be encouraged to participate in salvage operation as it will minimize the damage caused to the environment and protect the environment. To do so, adequate payment will be given for the services provided for the protection of environment and for minimizing the damage to the environment.
The Merchant Shipping Amendment Bill 2015 provides for rights and duties of central government in cases of maritime casualties in protecting its environment and coastline. The bill also facilitates a purposeful approach towards removal of wreck and salvage. With cameraman Ashwini Kumar, Dipali Pandit for Rajya Sabha Television.
The new legislation, Captain, how do you see it impacting the compliances that a captain will have to ensure if the ship is getting in and getting out? The practical aspect of a seafarer. What do you think? Where do you see it?
To have his paperwork in order, he will have to have the certificate showing that the vessel is insured as per the requirements. That's all he can do. But once the wreck takes place, he cannot do anything further than saying that he has got his paperwork in order. Really, practically speaking, he's very limited. He's got very limited resources after that. Then it becomes the subject, a much bigger subject. It goes beyond the ship. It goes outside the ship.
But on the role of the, I get it, on the role of the salver, that's where your role comes in again. So as a salver, you have now a reward happening. So how do you see that part of the
I don't know
legislation?
whether the master is allowed in this to negotiate with the salver. I am not sure of that. Whether he can negotiate with the salver. This has happened. One ship which ran aground near the English Channel many years ago. A lot of legislations have come after that. The master refused the salvage. He thought that he could avoid paying the salver. So
do you see the addressing of this issue that?
See, if the fundamental difference between salvage and wreck removal is the fact that if in a salvage, a salver is compensated to the extent of work he is undertaken already. Unlike a wreck removal, because wreck removal stricto sensu follows the contract as also the principle of no cure, no pay. While in case of a salver, he is still compensated for equal amount of or the quantum of or the amount of work that he has carried out. Going back to a question on how a sort of seafarer will look at this, I think these are only things which will be helpful from the larger perspective or a larger picture to have all these compliances, to have insurances on board in order to, because you see at the end of the day, we are all talking about, the amendment is talking about, all the other conventions are talking about to maintain an ecological balance.
Correct.
Any change will have a reaction. Every change will make some sort of flutters in the instrumentalities, in the system. It will make things a little difficult. It will make things, there is a habit that we need to change.
So what you're saying is this is a good step, it's a step in the right direction.
It's definitely a positive step. Definitely.
Okay, now I'll bring you to the definition of hazards.
Yes.
Now, it has been codified very specifically. Now, if you read it or try to understand wreck removal with the hazards that have been codified or explained or elaborated or expanded, do you see wreck removal now really becoming a thankless job?
I think it's a well put question. Yes, wreck removal is only going to become more difficult. I think it's a very subjective thing to understand this whole concept of wreck removal. And as if you noted when at the outset I said, I think there needs to be expert in the state instrumentalities to understand as to what you mean by wreck removal.
Do we have any agency in the state?
It is, to my mind, the
Very limited.
The
They are there. The experiences,
Where all do we have and what is the capabilities?
not as much as they have in South Africa or Europe.
but I think it will be the
But
port authorities.
this is one place where we can, the India can step in, because we have a large coastline. So this is one place where the Indian entrepreneurs can get into. is wreck removal,
Every port, to my mind, has
which is a big scope
agency
in
which,
coming up.
So the state essentially will have to set up expertise-based institutions
Yes.
for its own needs, because eventually it's the ultimate responsibility of the state.
They are getting
And
affected.
as of now, there are none.
So you need to have a proper ministry looking into it. If you noticed in the River Princess case, it is the tourism ministry who's looking at it. With all due respect, I do not think that the ministry would have all the necessary expertise for a wreck removal. It is a ministry set up for a particular state, for a particular purpose and objective.
Implication on tourism.
I mean, it's difficult for them and for us to also, put an aspersion on them to say that, oh, they do not understand. But the point is that I don't think they are the correct agency to understand what is wreck removal. There has to be some experts.
Maybe the Coast Guard, Indian Coast Guard, or as far as India is concerned, or the Indian Navy could take it up.
They have
they have the means. They have the people who probably would be the right suited for this kind of difficult job, as Dhawan was saying. It's a very special, highly specialized job. So you have to understand the buoyancy of the vessel.
But in the civil sector, we don't have any.
No, not at all. Not at all.
Even the shipping Ministry of Shipping.
No, not at all. You have to bring in the naval architects, to get into this field. The naval architects, the salvors, the experts, the engineers, they all need it.
Do you see this bill creating or opening up that opportunity?
I hope so. I hope.
Do you see that happening?
Definitely. I think just to come back to the earlier point, I think the DG, the Director General, is, to my mind, the nodal agency, which looks at all these issues. And I think he is the person directly responsible in case something like this happens, to do all the reporting and ensuring that proper compliances and checks and balances are put in place. I would want to say this, that I think incidents of salvage and wreck removal are here to stay. There will be incidents which will happen in future. I think this is a positive move. We need to encourage the private sector to get into this. How we encourage them is by ensuring that this principle of no cure, no pay is interpreted liberally and not in that stricto sense, so that no person is wanting to get into this area and wanting to, carry out forward. So
on that note, moving on, my colleague Deepali Pandit spoke to Prashant R. Govil, former development advisor, Ministry of Shipping, to get his point of view.
So how would these amendments affect the environment?
Because the Indian Merchant Shipping Act in 1957 was quite old, and over the period of time, there are a lot of changes in marine propulsion systems and other things. So a lot of pollution increased, sea pollution, air pollution. So these amendments certainly try to improve pollution and bring pollution-free, global environment.
So do you think this bill would help India meet international shipping standards?
Yeah, certainly, because these international standards are derived after this International Maritime Organization is there, the MARPOL, Maritime Pollution and Control of Sea, is there, and they come out with number of resolutions every year. And the Director General Ship in Mumbai, they participate in all the deliberations in Geneva, London and other places. So Ministry of Shipping has been constantly in touch. This is a part of Shipping Ministry. So they certainly do this, take into consideration all these deliberations, and then they have come out with the bill. As far as shipyards are concerned, I can assure you that they will try to implement all the requirements, all the provisions of this Act.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.